Accessory after the fact. Amoral vindication of the legal category. George Hull. Analysis, Volume 86, Issue 1, January 2026. Abstract: can an act of yours, unpremeditated and not begun until after my wrongful action, make you morally complicit in my deed? The ancient common law says it can. Modern commentators demur, holding an accessory after the fact to be an accessory in name only. I argue that the common law has right on its side. Often what one has done and what wrong one is responsible for having committed are determined, in part, by factors not within one's control. But those factors are not necessarily within no one's control. When, intentionally but without prior coordination, you act in such a way as to make the wrong I have performed more wrongful, more harmful, or a wrong which stands unannulled for longer, you make yourself my accomplice, by changing, worsening, what I have done. I argue that moral philosophy should recognize the accomplice liability of accessories after the fact. This is an open access article distributed under the terms of the Creative Commons Attribution License, which permits unrestricted reuse, distribution, and reproduction in any medium, provided the original work is properly cited. The ancient common law of England recognizes a principle in the first degree, the actor or absolute perpetrator of a felony. A principle in the second degree, he who is present, aiding, and abetting the felony. And an accessory, he who is not the chief actor in the offence, nor present at its performance, but is some way concerned therein, either before or after the fact committed. Blackstone 1769. 34-35. An accessory before the fact knowingly and intentionally provides prior assistance, causing, or tending to cause, the principal to succeed in committing their felony. An accessory after the fact, without having conspired before or during the felony's commission with the principal to do so, provides assistance later on. They might, for example, conceal evidence, drive the principal away from the scene, help the principal find a buyer for stolen goods, or mislead the police by supporting the principal's false alibi. Gillies, 1980. 270. The principal does not have to be aware of assistance provided by another party, whether before or after the fact, for that party's assistance to count as accessory to their felony. Traditionally, common law jurisdictions have held an accessory after the fact, through their accessory act, to have made themselves complicit in the principal's offence. An accessory after the fact is in the position of an accomplice in relation to the person charged with the original crime. Garrow and Willis, 1968. 66. He or she is someone who unlawfully and intentionally, after the completion of the crime, associates himself or herself with the commission of the crime by helping the perpetrator or accomplice to evade justice. Burkle 2016a. 741. In the eyes of modern commentators, however, to insist that an accessory after the fact is literally an accomplice in the principal's felony generates a contradiction. After all, if a party only begins even to think of assisting after the fact, how could their culpability possibly rest on participation in the bringing about of the substantive offence? Smith, 1991. 7. If conduct which does not have a causal effect is insufficient for accessory liability, how could conduct which only even begins to be planned after the fact be accessory? Understood as contributing in a more than minimal way to the primary wrong. Davies, 2015. 40. One might, of course, try dropping the requirement that even successful accessory acts have a causal effect on, make any difference or contribution to, the primary wrong. And accessory after the fact, according to this approach, might then simply be anybody who does something to associate or align themselves with the primary wrong retrospectively. However, this stretches the concept accessory beyond breaking point. Imagine that, following a dazzling jewel heist, a true crime aficionado writes a letter of congratulation to the perpetrator expressing wholehearted approval of and alignment with their deed. The perpetrator would legitimately balk at counting this correspondent as having in any way assisted them in their exploit. An assistant who contributes nothing to the enterprise is an odd sort of assistant. Equally, the letter writer would have a legitimate complaint if they were then arrested and tried as an accomplice in a theft. Modern commentators conclude that the accessory after the fact is accessory in name only. Rather than being complicit in another's offence, they have committed an independent offence, one not falling under general accessoryship, understood as rendering assistance to the perpetrator in the commission of the offence. Halavy, 2012. 121-22. They are guilty of the concealment, but not the commission, of the primary offence. Davies, 2015. 40. Of the distinct behaviour of preventing an existing offender's detection or apprehension, essentially interference in the process of bringing offenders to book. Smith, 1991. 7. But once it is admitted that there is no distinction between accessory after the fact liability and the crime of defeating or obstructing the course of justice or attempting to, any reason for a separate offence of being an accessory after the fact falls away. Burkle 2016b. 517, 519, and compare Buxton 1969. 265. The Criminal Law Act 1967 does indeed exclude it by statute in England. Here I attempt a moral vindication of the category accessory after the fact. My contention is not that all codifications of positive criminal law should include it. Rather, I argue that it is a legitimate moral category of responsibility and liability, one which needs to feature in a comprehensive moral theory. If it did not already exist, moral philosophy would have had to invent it. The law proscribes types of conduct, not types of person. What is primarily accessory, then, is an act. The actor is an accessory only derivatively. On the ancient conception, the accessory act which renders you an accessory after the fact to P's crime may be no crime considered by itself in isolation. For example, perceiving P running away from the jewelry shop he has evidently just finished burgling, a bag full of stolen jewelry upon his shoulder, police officers in hot pursuit, you offer P a lift in your car. In itself, offering someone a lift in one's car is no crime. In these circumstances, though, your offering P a lift is an act accessory after the fact to P's crime, namely theft. But the accessory act may, itself alone, also be a crime. Imagine that in the scenario described just now, you aid P in his escape by assaulting a police officer. In these circumstances, your criminal act of assault is aggravated by its also being an act accessory after the fact to P's crime, namely theft. Why think that a morally permissible act can be made wrong, or a wrong act made worse, by being accessory to another person's prior wrong act? Turning it the other way around, why think that an already committed wrong can acquire a new accomplice through unpremeditated acts subsequently performed? For a start, when I commit a crime, or do something morally wrong, what crime I commit, or what wrong, is quite standardly dependent, in part, on circumstances beyond my control. Imagine that, walking over a pass, I encounter a boulder perched at the top of a steep ridge. For the fun of it, I lever the boulder up and over the edge to watch it crash down the mountain slope. You already know I have done something immorally and criminally reckless. But whether I have committed manslaughter or some other form of unintentional homicide depends on whether there are people walking beneath. Even if there are people there, it will also depend on, say, whether the rolling boulder hits a tree which diverts it onto the walker's path, or just grazes that tree and misses the walkers entirely. What wrong I have committed, and what wrong I am responsible and liable for committing, are, in part, a matter of luck, of contingency. Once one sets an action in motion, there is a, sometimes considerable, extent to which how things turn out determines what one has done. Nagel 1979. 29-30. When stated so broadly, it may be discomforting to recognize that one is responsible for what one actually does, even if what one actually does depends in important ways on what is not within one's control. Nagel 1979. 35. It may even conflict with some other beliefs and commitments we have, but it certainly reflects a moral judgments. Nagel 1979. 35. The second point to note is that determinants of what wrongful act I have in fact committed, which are not within my control, need not be within nobody's control. Instead of there being a tree, bumping into which diverts the boulder onto the path where the walkers are, there might be you standing there, having observed what I did, and ready to use your extra strength, steel. Reinforced trekking poles to divert the boulder knowingly onto the path where the walkers are. In doing so, you commit your own wrong action, a self-contained crime of your own. But that is not all. You also change what I do, what wrong act I end up committing, and how much wrongful harm I am responsible and liable for, depend here on factors which, though outside my control, are within someone else's. Yours. Take another case. I shoot somebody in the street, shooting to kill. Standardly, whether I have committed murder or attempted murder is going to depend on factors beyond my control. Whether the ambulance called by a bystander gets stuck in traffic or arrives in time to stop the victim from bleeding out, for instance. But it might not be unknowing motorists on the roads who prevent the first responders from getting to the victim. It might be you who, having observed everything, decide to assault the paramedics as they exit the ambulance. In doing so, you commit an act of assault which, taken purely by itself, is wrong and unlawful. But you do something more as well. You make my action a murder rather than an attempted murder. Your act changes what I have done. Not only does your act change what I have done, but you have also, surely, taken upon yourself some of the liability for that deed, the murder I committed. It is, after all, because of you that it's the case that I committed murder, rather than just attempted murder. You are now partly responsible. Compare the position of an accessory before the fact. The person who supplies a working firearm, for instance, or an effective poison, in advance, so that when the time comes, rather than trying but failing to commit murder, the principal commits murder. The accessory before the fact, through prior provision of an instrument, in this case, contributes to making the principal's action into a murder rather than an attempted murder, as it would have been if the principal had just used their hands, say. That is why they are an accomplice in the principal's wrongful and criminal act, because they have contributed to making it the wrongful and criminal act it is. In doing so, the abettor before the fact has taken upon themselves a degree of, albeit indirect, responsibility and liability. The liability of an accomplice. Equally, when you prevented the paramedics from reaching the victim by assaulting them, you contributed to making my crime of murder the crime it is. Parallel counterfactual propositions apply in the two cases. If the accessory before the fact had not supplied the instrument, and no one else had done that, and no chance set of events which had the same effect had occurred, then it would have been attempted murder rather than murder. If you had not assaulted the paramedics, and no one else had done that, and no chance set of events had occurred with the same effect, then it would have been attempted murder, not murder. In both cases equally, this is why the secondary party has not only committed their own independent wrong, but has contributed to making the perpetrator's wrong into the wrong it is. In both cases, the secondary party has made the perpetrator's crime worse, and in so doing has made themselves partly, albeit indirectly, responsible for that crime. As an accomplice, just as a principal may try and fail in their endeavor, ending up responsible only for an attempted crime or wrong, so a secondary party will sometimes be responsible and liable only for attempted accessoryship. There is potential for at least two kinds of failure here, two kinds of merely attempted accessoryship, whether before or after the fact. The secondary party may succeed in supplying assistance, successfully do something which in the normal run of events would have the envisaged effect, but the principal bungles. They spill the poison supplied as agreed before the fact. Misplace the fake passport supplied after the fact without prior agreement. Differently, the secondary party may try but fail to supply assistance. The firearm, unbeknownst to them, is a dud, the getaway car stalls and will not restart. If accessory liability accrues to the successful accessory for what their action actually brings about, it accrues to the attempted accessory for what their action tends to, would in the normal run of events, bring about. Or at least is intended to bring about. This is how we can make sense of overdetermined accessoryship as well. If you assault a police officer to aid jewel thief P in his escape, only to find someone else has driven him away to safety in their car, then it is, in the event, not your act which enabled P to evade capture. Nonetheless, the act of assault you carry out is also an instance of wrongful attempted accessoryship to theft, as you intended it to enable P to evade capture, and it would, in the absence of the getaway driver or some other chance set of events, have had just this effect. Many classic instances of acts accessory after the fact to another's crime involve, as we saw at the outset, helping a perpetrator escape capture or helping a perpetrator evade justice after they have committed their crime. It might be doubted whether the account I have offered so far can cover such cases. Do you really change what P has done when you unpremeditatedly offer him and his bag full of stolen jewelry a lift away from the scene of his crime? You do. In the jewel thief case, though, unlike in the paramedic assault case, that is not because you change what type of wrong P has committed. The wrong remains theft before and after your intervention. What your intervention does change, however, are morally relevant features of P's offence, features with concrete implications for moral liability. The longer a thief and their loot evade capture, other things being equal, the greater the harm their wrongful act of theft does. In a case, the jeweler is deprived of the benefits of possession for longer. What is more, the longer the thief evades justice and is not punished, the longer their wrongful act stands without being righted, the longer the perpetrator's affront to the victim's value or dignity, their claim to mastery or superiority, goes without being annulled or defeated in the way it can be by just punishment. Hampton, 1992. 1666, 1690. Justice delayed, other things being equal, makes the perpetrator's wrong into a worse wrong, by making it a wrong which stands unrighted for longer. The same is true of acts accessory before the fact. Many of these change not what type of wrong is committed, but rather morally relevant features of the wrong, such as how harmful it is, or how many people it harms, or how grave a wrong it is. P is set on robbing the jewelers, but has only his bicycle basket to carry the jewels away in. I lend him a lorry to assist. By doing so, I do not change what type of offence he commits, but I do change how much harm it does. How many jewels get taken, because more fit in the lorry. My changing P's theft into a more harmful theft by supplying the lorry in advance is what makes my act of lending an act accessory before the fact to P's wrongful act. Likewise, after the fact, you're giving P a lift or assaulting a police officer and thereby changing P's theft of jewels into a more harmful theft because the jewels remain unrecovered for longer. Changes morally relevant features of P's wrongful act. X's act is accessory after the fact to Y's morally wrong act if, knowingly and intentionally, but without prior coordination or planning, subsequent to Y's act X behaves in such a way as to change what type of wrong act Y has performed, making it a more severe type of wrong, or in such a way as to increase the harm of or increase the number of people harmed by Y's wrong act, or in such a way as to render it a graver wrong of the same type, or in such a way as to increase the length of time for which Y's wrong act causes harm or stands unannulled. To be an accessory after the fact, X must in addition act in a way which accords with Y's intentions in action sufficiently to count, broadly speaking, as aiding Y. Modern commentators have been too quick to dismiss the ancient common law category accessory after the fact as self-contradictory. The appearance of contradiction is dispelled once it is acknowledged that what I have done and what I am responsible and liable for having done are frequently determined in part by factors not within my control. B. Those factors not within my control may include, in certain circumstances, the knowing and intentional, though not previously planned or coordinated, act of another person. C. When another's knowing and intentional act increases my responsibility and liability for a wrong or wrongful harm. It would be intolerable to allow that they could in this way increase my responsibility and liability for my wrongful act without taking upon themselves some responsibility and liability for the wrongful act of mine whose wrongfulness or harmfulness they have increased. Though the act is not directly and primarily theirs, it is indirectly theirs. They are now an accomplice in it. Once the category accessory after the fact is no longer restricted to legal contexts, the demarcation of acts accessory after the fact can proceed without reference to the law's, sometimes idiosyncratic rulings, on when exactly an action is complete. A tricky question at the best of times, for the resolution of which I offer no general formula here. Once accessory after the fact is accepted as a moral, rather than purely a legal, category, it might also be worth investigating whether only actions or also other types of thing, for instance, the basic structure of a society, could be accessory after the fact to past wrongs.